Hello, everyone. Sufit here. I'm here today with Charles Ticker, author of Bobby Gets Bupkis, Navigating the Sibling Estate Fight. Charles is a mediator at siblingestatedisputes.com. Welcome, Charles.
Hi, Sophie. Good to be here.
I have an interesting question for you today, and it's, I think, a common issue that comes up in estate matters. We have some adult siblings, and while the parents are alive, or one of the parents is alive, this parent gives gifts, let's say, to one of the three children. Later, this parent passes away, and the estate, let's say it's $1 million, and the parent wants to treat everyone equally, so splits it, a third, a third, a third to my three children. Is that likely to cause a problem later when the estate is going to be divided?
Um, Good question, and the short answer is yes. There's a very good chance, particularly if the family, the siblings don't get along that well. There's a very high chance of a dispute after the parent dies because the other siblings that did not receive the gift uh, during the parent's lifetime are going to say, "Well, wait a minute, this isn't fair. This is not equal. You already got $100,000, let's say, and we don't think it's a gift. We think you should, pay it back to the estate or make an adjustment on what you get from the estate." Then you get this fight over it. Was it a true gift, or was it a loan, or what, or was it an advance on the inheritance? What was it? So yeah, it's a very common scenario that I see it at my mediations, and it's a problem that cannot, that can be rather easily avoided if proper steps are taken. Not avoided maybe 100%, but certainly uh, ways to minimize the risk of a dispute.
Okay, so let's say proper steps are not taken, whatever those proper steps may be, maybe documentation or whatever you were suggesting. Um, Proper steps were not taken, so the dispute was not easily avoided, and we're here. Um, does do Let's say there are three siblings, so we've got the favored sibling who got the 100,000 as you suggested, and then you have the other two who think it's not fair. Wasn't
Correct.
it Tina Turner who sang a song, "What's Fair Got to Do with It," or something? Like what?
I
Like
think well, it was something. I think it was what's love got to do with
what's
it.
love
But
got to do? Yeah, but it's
and
all it's
and
all
and
like
so like well, this is it. Mom always loved you best, and she gave you $100,000. Yeah, yeah. I'm
does
sorry. Go
mom
ahead.
have to be does mom have to be fair? Number one, and number two, what's the definition of fair?
Well, certainly in the jurisdiction where I practice, the issue of fairness doesn't really come into play in this sort of situation. A parent doesn't have to treat their children equally, um, um, but uh, that doesn't prevent a dispute if, like you said, it hasn't been properly documented at the time the gift was made as to what the intention of the parent was. So no, the parent doesn't have to do anything, but the parent hasn't done anything wrong. But if it's not documented, or if they haven't had a proper disclosure made to the family, the other children are going to think, well, maybe mom didn't really freely make that gift. Maybe the parent was unduly influenced by the other siblings. So it leaves open all kinds of doors for a possible challenge.
So let's okay, I hear you. So let's say that the other two are not able to establish undue influence. The mom just felt sorry for this kid. Maybe it was the baby of the family. Maybe she doesn't have such a great job and the other two do, or whatever the reason. The mom gave the gift. The mom knew that she gave the gift. Um, do these other two have a leg to stand on in court? Is there a chance that they will have that gift considered to be a loan by the court? Like, what would they have to prove in order for that to happen?
Well, they would have to uh, show that the parent lacked capacity to make the gift. And where it gets a little complicated, I don't want to get too technical. If the gift is made to a child, and particularly a child who's acting as, let's say, as helping the parent out or acting as an attorney, for property or for personal care, their questions may come into play that the onus is on the recipient of the gift to disprove undue influence, or to prove that the parent had capacity to make that gift. So what happens is, nobody, as I say, the mediations, you never know what's going to happen at court, and what a judge is going to do. There's this uncertainty, and so if people are going to get into litigation in this area, what happens, and it may not be what the parent wanted. The parties will get to mediation, and they're going to try and settle their differences, and it very likely might mean that the child who got the gift may have to give some of it back to avoid the risk of losing at court. It's unfortunate, um, but if proper steps weren't taken at the time the transaction took place, to at least document it and try and bulletproof it as much as possible, there is that risk.
Okay, so before we end today, I'm going to really be difficult and I'm going to really pin you down. Let's say there is no sniff of undue influence. Let's say there is no sniff of, I don't know if that's the right word, but no intimation that the testator lacked capacity to make the gift. Let's say this third child did not help the parent out. Let's say there's none of these circumstances. All you have is parent giving child A this gift with none of these other circumstances. And let's say child 2 and 3 cannot prove any of these other circumstances. Are you saying actually that number one, that the court would put the onus on the receiver of the gift to prove it? And number two, even if the owner, the recipient of the gift could prove it, is there still a chance that it could be characterized as a loan rather than a gift? And what would 2 and 3 have to prove in order to convert that gift into a loan?
No, I think the onus in that situation would probably be on the challengers,
Yeah.
they're raising the issue of undue influence, and they're going to have to prove it or lack a capacity.
Let's say they
Uh,
can't prove those. Yeah.
but yeah, you're very right. Based on these facts, it's most likely they're not going to be successful in challenging that gift, and they are going to lose, and have to
Unless
pay
they
a lot
could
of
prove it
costs.
was a loan. Unless they could prove
And
it was a
alone,
loan.
yeah, or if they can prove it's a loan, once again, to show that was a gift, was it intended as a gift at the time? Um, and uh, and the best way to do that is just have the parent write it out on a piece of paper saying, "This is a gift." Mind
Sorry, the
you,
parent's not around anymore.
but when they made the gift, that's what they should have
Yeah.
done, right?
Yeah.
Or
Yeah.
had a lawyer document it. But but what unfortunately in this area of the law, if people have the means to litigate and they want to litigate, they're going to litigate, and
Right.
that's just the way it goes sometimes. But certainly, parents who are making large gifts to their children during their lifetimes and to the exclusion of other children should properly document it, and may also consider disclosing and having a discussion with the family as to the reasons for it while they're alive, so people don't guess after they're gone.
Thank you very much. Well, we've been discussing and dissecting, and I've been really hard on you, Charles, and you did really well in response. So thank you for that.
Okay.
We've been dissecting the issue of what to do, what kind of a case do siblings have when another sibling got gifts within the parent's lifetime and then the estate is um, settled or distributed, quote unquote, equally. By the way, I know you're not going to plug your book, so I will, but Charles covers the concept of equal, not fair, and unequal, not fair in chapters 3 and 4 of his wonderful book, Bobby Gets Bupkis, Navigating the Sibling Estate Fight. Our guest today has been Charles Ticker, author of Bobby Gets Bupkis and mediator at siblingestatedisputes.com. Charles, thank you very much.
My pleasure as always. Thank you.